In Navarrete, California, an anonymous 911 caller reported a reckless driver, but the police found nothing wrong with it and stopped the truck anyway. The Supreme Court said that's legal, and here are the nuts and bolts.
Welcome to the Cuffs and Case Law podcast, where we read case law so you don't have to. In August of 2008, an anonymous
Lord.
caller called 911 about a reckless driver. They called 911. That 911 call was routed from Humboldt County over to Mendocino County.
I definitely know where those two places are.
And it's in California.
Okay. It's a big state.
But that happens all the time, right? Whenever you call 911, it routes to whatever your local 911 center is. Then they figure out where you are. They may transfer you to a different 911 center. And that's what exactly what happened here.
Which will be more difficult in 2008 than it is now.
Yes. So the Mendocino County 911 dispatch team dispatches for the California Highway Patrol. So a caller comes in and says, hey, we're southbound at Highway 1 at mile marker 88.
It's along the ocean.
I think it is, right? But
that's important to this discussion.
It's not. We're near
I need the scene to be laid out.
We're near mile marker 88, and there's a madman driving.
Madman.
Won't somebody please think of the children?
I do think of him on a daily basis.
So they say, hey, there's a silver Ford F-150 pickup. They give the full license plate of 8 David 94925. They ran the reporting party off the roadway and was last seen approximately 5 minutes ago.
Ran off how?
That's all it says. So the Mendocino County team then broadcast that information to California Highway Patrol officers, CHP officers, troopers.
I don't actually know.
CHP guys, troopers.
Might be
the CHIPS guys, the California Highway Patrol guys.
Famous show before I was born.
This says officers, but I feel like they're troopers.
If it says officers, it's officers.
Anyway, it comes in at 15:47.
We lost the entire California audience we didn't have.
Yeah, true. So this is dispatched at 15:47 hours, which for you non-military types is 3:47 p.m. So this is dispatched at 3:47 p.m. Now,
you said August
of 2008. The decision wasn't rendered until April of 2014. To give you some context on how long this can take to make
its way. Not very long when you're showing those fingers, but it's long in this house.
This process of working its way through the courts before you are rendered a final decision in this case took 6 years.
What exactly are we doing in between now and then? Because I'm stopping cars on anonymous tips between 2008 and 2014.
So you're going based off whatever because it's not decided yet. So whatever
not binding if one
not
would
binding yet.
Apply some knowledge.
Look at you. All right. So call comes in at 3:47 p.m. The CHP guys are dispatched at 4 p.m., which for those of you that are bad at math is like 13 minutes later. CHP guy heading northbound towards the reported vehicle passes the truck in question.
He says, that looks awfully familiar.
Yeah. So if you remember, the initial caller reported that it was near mile marker 88.
He's now
at mile marker 69.
Outstanding. And that is why he's working that area, because he gets the report that he's stopping cars.
So he finds
mile marker 69.
So
also nice.
At 4 p.m., this CHP guy sees the truck heading the other direction at mile marker 69. So he turns around, flips on him. Approximately 5 minutes elapse. So for the unattentive listeners, that means that in totality, we're at about 18 minutes from the original call. Now, that CHP guy flips around and he doesn't stop the car until 4:05. That means
he directly behind the car?
He's catching up to it, and then he drives behind it for a while, and he confirms, hey, this is a silver Ford F-150. And in addition to that, it's got a plate of 8 David 94925. They gave the correct plate.
Which is rare, as we all know.
Yep. So another CHP dude, was also looking for this truck at the same time. So he pulls in to back them, and the primary officer, trooper, whomever, He doesn't have any violations. His probable cause is out the window. Believe it or not, this is going to be shocking to you. When two troopers swoop in behind this guy, he is now driving like a church deacon.
No.
And he is following.
It's called change of behavior.
So he's now following every single traffic law. He doesn't have any equipment violations or anything like that. So probable cause is out the window. Furthermore, he's not bobbing and weaving. He is not
running other people off the road.
Won't somebody please think of the children? The children all appear to be safe. So
shouldn't be on the highway anyway, but
he has no independent RAS. But he stops the car. He stops the car based on the information alone from the anonymous caller.
Which he confirmed.
He verified some of it, yes. And we'll get into that. But
not the running off the road part.
No, he didn't see anything like that.
There's no talks of damage or anything that he could see. And There was no alleged crash.
Nope. None of that. So it is, hey, an anonymous person calls me and says, this happened. I find the car and then I stop it.
After several minutes.
Yes.
Because we've all been there and you find it and you're like, well, time's ticking. How long do I have before this is no longer fresh?
Now, here's where this gets fun. So they walk up to the truck to conduct their traffic stop, and they smell the odor of marijuana. Remember when marijuana was illegal? Those were the good days.
No, now it feels like forever ago.
It really does, actually. But at this point in time, marijuana was still illegal. So
I guess depending on what state you're in.
So
is it all 50 now?
I don't think so.
Okay.
But
depending on what state you're in.
Anyways, marijuana was still illegal. They smelled the odor of marijuana coming from the truck. They searched the bed of the truck, and there were 30 pounds of marijuana in the bed of this truck.
It's a lot of pounds.
Because of course there was, right? This is how we make case law.
Because it wouldn't matter if he had nothing in the car.
Nothing, right? That is my exact point. So case law is not made when you stop a car on RAS from an anonymous complainant.
And write them a speeding ticket.
That's not going to make case law. There's always some crux. There's always some gotcha moment where, hey, I don't know if this warrantless entry into the home was okay. And then you find a dead body. Right? There's always something, there's always some huge pivot point that makes this a thing. In this case, it was 30 pounds of marijuana.
Dead bodies, drugs, and guns, generally.
Yes, usually it's one of those. So that is how case law is made, and that's why we have Navarrete. So the troopers arrest the driver, who is called the petitioner in case law, and that driver's name was Lorenzo.
We call him defendants.
Yes, Lorenzo Prado. Lorenzo Prado Navarrete. They also arrest his passenger, Jose Prado Navarrete. Now,
of no relation.
So believe it or not, when they get to court, they file a motion to suppress the evidence.
As all of them do.
They argued that the traffic stop violated the Fourth Amendment because the officers lacked reasonable suspicion of criminal activity. Why'd they do that?
Because they want to get out of the 30 pounds.
How does it get?
Marijuana.
Well, how does you got to bridge the gap here? if explain that to me.
Not my weed. Because if you couldn't search or you couldn't stop me, I guess we'll back up. You couldn't even stop me.
Yep.
Then you certainly couldn't see anything, and you certainly couldn't search anything to find anything that's criminal to then arrest me.
So what is that called in legal jargon?
Fruit of the poisonous tree.
That's the name of the doctrine. What is it?
Fruit of the poisonous truck.
No. Fruit of the poisonous tree is correct, right? That's a good way for us to understand it, because if you have,
is it mostly correct?
It's substantially correct.
Thank you.
So you have a tree that is poisonous, then its fruit is also likely poisonous. That's why we have that analogy. But what is it also called? What's the more legalese? The more legal,
a Fourth Amendment violation?
Yes, but there's a specific thing that I'm looking for.
What did I just say? If you're hearing me correctly.
If I'm hearing you correctly, what I'm hearing is that that is called the exclusionary rule.
No, definitely was not going to get there.
So the exclusionary rule is a legal principle that bars illegally obtained evidence from being used in criminal trials. So if anything, any evidence is obtained from a violation of the Constitution, more than likely the Fourth Amendment, if it's obtained in an illegal search, it can't be used against them in court. So the further back they can,
Still get them on the traffic violations,
you
though.
can. Well, no, because you didn't see
didn't
any.
even have any.
so the further back that they can
That's why
issue,
we push this.
yes, the further back that they can issue that motion to dismiss, right, the more the rest of it goes away. So if I can attack, as a defense attorney, if I can attack the reason for the stop and I say you weren't legally justified in stopping me in the first place, the rest of this goes away. The 30 pounds goes away because it's the result of even if it's a legal search, right? Even if it's a legal search pursuant to the motor vehicle exception to the search warrant requirement of the Fourth Amendment, if I can attack the stop and I can say you couldn't have stopped me in the first place, then everything from that point on, everything goes out the door. So these two guys who are definitely not siblings, Lorenzo Prado Navarrete and Jose.
Did you
Prado
look that
Navarrete.
up?
No, I didn't. They're 100% siblings. I don't know if they're brothers or cousins or whatever.
Do we know what they were doing on that day?
Moving 30 pounds of marijuana is what they were doing.
Fair.
So the magistrate who presided over the suppression hearing and the next step in up the flagpole both disagreed with these fellas. And they said, nah,
We're good.
We're good. And so
don't drive marijuana up route.
Yeah.
One.
And then the California Court of Appeal affirmed that decision. Anyway, long story short, it made its way all the way to the Supreme Court of the United States. Supreme Court now has to answer this question of, can an anonymous tip?
Which, as far as I know, they don't have to go try to answer the question.
They don't. They can refuse it. They can say, yep, we're not gonna hear this case. And if that is what their official stance is, then whatever last determination down the flagpole was made, that is what it is.
Do we have a time limit on how long that they can choose to or not to accept?
Man, that is an excellent question. That
you know
I don't
what?
know
You
the
should
answer
look that
to.
up and report back to me.
Yeah, I don't know, but I will find out.
I feel like it's probably not actually defined, because why would the highest authority want any
limitations?
Yeah.
No.
Be
Again,
like, you know what?
But to your point, I don't know, but I will find out is always an acceptable answer. All right. So in reviewing all of this, the United States Supreme Court sat down, they heard the facts of the case, they reviewed all the decisions before, and as we alluded to earlier, the Supreme Court went back and started looking at other cases that had been decided to see...
Don't you knife hand me.
Sorry. To see if there's any consistent legal precedents that they can use as a justification for the decision that they come to. All right, so in reviewing this case, the Supreme Court broke it down into several main things, and we're going to go by each one of them one by one in trying to decide whether or not this was reasonable for the troopers to stop. So the first thing that they evaluated is that the 911 car,
the 911 car,
the 911 call bore adequate indicia.
No, that word. I heard that one in my audiobook a lot.
I did this for you. So indicia is a big word like mayonnaise that just means signs, indications, or distinguishing marks that lead to evidence, right? So
say that again.
Signs.
Into the mic.
Signs, indications,
you'll learn,
or distinguishing marks that lead towards evidentiary value. All right. So they decided that, okay, in this case, the 911 call has sufficient indicia of reliability for the officers to credit the caller's account. And one of the first things that they pointed to is that the caller is saying that they are an eyewitness to this situation. So whoever called 911 didn't say, hey, my buddy just told me that there's a madman.
Also known as hearsay?
There's a madman driving on Highway 1. Instead of that...
Or my daughter told me this 10 minutes ago.
Correct.
As we find out a lot.
All the time. So instead of that, they pointed out that the caller is actually an eyewitness to this.
It's a good start.
That is
because the action was against them.
Yep, that is one part. So by reporting that she had been run off the road by a specific vehicle, a silver Ford F-150 pickup with the plate. The caller necessarily claimed eyewitness knowledge of the alleged dangerous driving. So the second thing that they pointed out is that there was apparently a short time between the alleged reported incident and the 911 call. And they said because not a whole lot of time elapsed, the caller probably didn't have a whole lot of time to fabricate this and make this up.
But she had enough time to get the plate correct.
Correct.
So she wasn't that scared.
No, but
I'm so scared, but I'm going to fall right behind him. We've also heard that plenty.
plenty of
I was
time.
afraid for my life,
So,
but I followed them until you got here.
so earlier you missed the opportunity to use the word afoot, and I'm
Yes.
still disappointed about that.
Mhm.
But I'm going to give you another fantastic word, and that word is contemporaneous.
Ooh,
So jot that one down. Long story
I'll
short,
never read it if I write it. So.
I know you won't. So there, quote, there is also reason to think that the 911 caller in this case was telling the truth. Police confirmed the truck's location near mile marker
69.
roughly 19 highway miles south of the location reported in the 911 call at 4 p.m., which was roughly 18 minutes after the call. So they traveled at highway speeds for 19 miles in 18 minutes, which is super reasonable.
About 60
Yeah, exactly.
or
So
69.
that timeline of events suggests that the caller reported the incident soon after she was run off the road. That sort of contemporaneous report has been long treated as especially reliable. So the caller
Based on previous case law.
the caller is an eyewitness. The caller gave sufficient descriptive information of the truck, and all the timeline matched up. Not only did the timeline match up, but the location matched up too, right?
Of the direction she claimed he was going.
Correct. Plus the time at the average speed, all of this is lining up. So the next thing that they pointed out is that a reasonable officer could conclude that a false tipster may think twice before calling 911. So they pointed out that this caller called 911 instead of the non-emergency line.
Dangerous game to get into someone else's head.
Yes, but why does that matter? Why does it matter that the caller called 911 instead of non-emergency line?
Because they believe there was an emergency.
One, what's the other part?
Because they don't have time to go look up what the local phone number is.
That kind of goes along with one.
No.
Wait, if it's an emergency, you're not going to go do it, right?
That's
So
a
you're kind of
different one.
nope. I'm not giving you a point for that. You have
I
one
haven't
point.
earned a lot.
You have 1 point already. Okay, so is that it indicates to that the caller at least perceived that this was an emergency. Why else is it important?
That they called 911 instead of non-emergency.
Yep. And remember that this entire case is based on the question of can we make a stop based on an anonymous caller? Hint.
Other than that, they probably got a phone number from 911.
Is 911 really anonymous?
You can say you want to be anonymous,
But what?
Probably not.
Right. So if we wanted to do the
My
legwork,
dispatch friends will be very upset with me for not knowing that.
so yeah, but if we wanted to do the legwork, we could probably figure out who the caller is, right? We have ways, and let me just
Do they end 2008 though?
Yes. May I quote this to you?
You may.
A 911 call has some features that allow for identifying and tracing callers and thus providing some safeguards against making false reports with immunity. So they said, okay, look.
Why does SWAT exist then?
Well, people have gotten better at doing this over time since 2008.
Yeah.
So they said, all right, the caller is firsthand eyewitness. They gave sufficient descriptive information in this car, the timeline, the distance, the location, all of this matches up. And they called 911. So even though they're anonymous, they're probably not exactly anonymous.
Do we know why they were anonymous?
No.
Because that's a question.
It is not covered in the case brief.
Did they say, I declare I'm anonymous?
So,
or they just said, nah.
And a lot of the other point about 911 is a lot of jurisdictions have it written into their laws that if you call 911 for no good reason, it's actually a crime. So that also deters people from.
Those would be lovely jurisdictions to work in.
They would be, right? So the next thing that they said is that this tip created reasonable suspicion of
Just that tip.
drunk driving, which is a serious, dangerous, and ongoing offense. If we go all the way back, right, it's got to be criminal activity that is afoot. So it has to be a crime.
Not just I don't like it.
Correct. And it has to be ongoing. So it needs to be a serious and dangerous offense. So
that's not a hate crime, Michael. Well, I hated it.
So unconfirmed reports of driving without a seatbelt or slightly over the speed limit, for example, are so tenuously connected to drunk driving.
Tenuously.
Yes. Think thin and flimsy. Thin and flimsy. Anyways, so it is so tenuously connected to drunk driving, which is the serious offense / the crime that we have here.
Well,
that a stop
running off the road, I don't know. That could be anything. That's a road rage these days.
But the officers testified that they presumed it was a drunk driver.
Oh.
And so that's what they're saying is the crime here is drunk driving. And this is a serious, dangerous, and ongoing offense, right? So if it weren't a serious, dangerous, and ongoing offense, that a stop on those grounds alone would be, and I quote, constitutionally suspect. So it's got to be a serious offense. It's got to be ongoing, and it's got to be a crime because we're working on RAS here. All right. So the 911 caller in this case reported more than a minor traffic infraction and more than a conclusatory allegation of drunk or reckless driving. So it's more than just, I think that guy's drunk. It's, hey, he just about ran me off the road.
Or did, allegedly.
Right. And the last thing the court says is that reasonable suspicion, quote, need not rule out the possibility of innocent conduct. So instead of hindsighting this and being a Monday morning cornerback and might be like, well, he might have accidentally tried to run her off the road because he spilled hot coffee in his lap. We don't have to take that into consideration. If it's reasonable for us to suspect that he is drunk driving, that's all you need to know. You don't have to think of all of the million different variables that could account for why he did what he did. We don't have to take that into consideration. And that does not dispel our reasonable suspicion. So based on all of that together, the United States Supreme Court said, yes, you can stop a car on an anonymous complaint that can be rooted in strong, reasonable, articulable suspicion that justifies that stop based on the totality of the circumstances, which is what you got to right off the rip here. So in these cases, or in this specific case, they listed those reasons as why that RAS was good. So it's not carte blanche, and it almost never is in case law. They're almost never going to say, yes, you can stop every car on an anonymous complaint because it makes no sense.
No.
But it gave us some things to think about, right? So why is this important to you? Why is this important to the police officers? You have to have the confidence. To be a good cop, you have to have the confidence to take action based on reasonable suspicion alone. You can't always wait until you have probable cause. You have to be able to be confident to take action on reasonable suspicion. So when you are going through that equation in your mind and you're doing that debate in your mind, this can give you some guidance on what to think about in determining whether or not your reasonable suspicion is likely to hold up in court, because the Supreme Court said these things together are good to go. That's all I've got. That is Navarrete v. California. Everybody out there, drink more water. Stretch your hamstrings. They're probably tight.